Let's dive right into this We and Law explainer. Today, we're unpacking how a simple, everyday party photo turned into a massive, incredibly costly legal lesson about your personal privacy rights. Seriously, if you've ever had your picture snapped at a public gathering, you're going to want to pay very close attention to this. So here's our quick roadmap for today. First, the unauthorized event photo. Second, why the organizers lost. Third, image rights in Nigeria. Fourth, heavy fines for businesses. And finally, key lessons for everyone.
But hey, real quick, before we completely decode this fascinating case, make sure to hit that subscribe button and ring the notification bell for the We in Law channel. We're all about bringing you top-notch civic education for development, and trust me, you won't want to miss our upcoming explainers.
All right, part one, the unauthorized event photo.
So I want you to imagine something for a second. Picture this. You dress up, go out to a super fun gathering, have an amazing time, right? But then, weeks later, you find your face plastered all over social media. And it's not just some cute memory being shared. No, it's literally being used as a commercial ad to sell tickets to complete strangers. And the kicker? Nobody even bothered to ask you.
Well, this is exactly what happened to a woman named Antoinette Rombo Aiko. She attended an event, just minding her business, only to realize later that the organizers were actively blasting her image across all their social media pages. They were using her face to heavily promote their upcoming Blankets and Wine Tupatane Anja Summer Events 2025. And they did all of this completely without her consent.
Now, Antoinette didn't just sit back and take it. She felt her likeness was being wrongfully exploited for profit, and honestly, rightly so. She argued that her face carries actual personal and commercial value, and using it to drag in paying customers falsely made it look like she was officially endorsing their brand. So this led to a massive, landmark legal complaint against the event organizing company, Good Times Africa.
When trying to settle it amicably went absolutely nowhere, she took her grievance straight to the top, the Kenyan Data Protection Authority, the Office of the Data Protection Commissioner. And what they uncovered and ultimately ruled on is something every single event goer and business owner desperately needs to hear.
Okay, let's move to part two, why the organizers lost.
Here's the really crucial point. Taking a picture of an identifiable person actually makes that photo personal data. Yep, your recognizable face falls strictly under this definition. The law says that if any business wants to use your personal data to boost their economic or commercial interests, like selling event tickets, they must get your clear express permission first. It's not some fuzzy gray area, it is legally binding.
In this famous case, Good Times Africa tried to defend themselves, of course. They argued they'd actually gotten permission through the general terms and conditions that are slapped onto the back of an event ticket. They were essentially claiming that by simply showing up to the party, Antoinette had magically agreed to become their free marketing material.
But the regulatory authority firmly, and I mean firmly, rejected that argument. They ruled that valid consent absolutely cannot be hidden away inside the tiny fine print of general rules. And it definitely can't be assumed just because someone bought a ticket. You have to actively, specifically agree to become a walking billboard. The burden of proof is entirely on the company here, and guess what? They had zero proof that Antoinette ever signed any kind of specific agreement.
So, because the company's handling of her data was declared 100% unlawful, she was entitled to financial compensation for the infringement and the distress it caused. The organizers were ordered to cough up 300,000 Kenyan shillings, and when we convert that to put it in perspective for us, it equals a whopping 3 million Nigerian naira. Talk about one incredibly expensive photograph.
Which brings us to part three, image rights in Nigeria.
Now, this brilliantly illustrates something super important. Even though this specific incident happened over in Kenya under their 2019 Act, a virtually identical outcome would happen right here at home. Why? Because the Nigeria Data Protection Act of 2023 gives us the exact same incredibly robust protections when it comes to commercial consent and your personal data.
Under our local Nigerian framework, the laws are seriously strict. Section 65 actually guarantees your right to seek financial compensation if a company violates your privacy. Section 26 places the burden of proof entirely on the company, making it crystal clear that silence, inactivity, or those sneaky pre-ticked boxes do not equal consent. Furthermore, Sections 35 and 36 give you the absolute power to easily withdraw your consent anytime you want, and to straight up object to your data being used for direct marketing.
Okay, before we dive into the incredibly heavy penalties that Nigerian businesses are facing for ignoring these rules,
please take just a quick second to hit subscribe and the notification bell. Supporting the We in Law channel helps us keep bringing you this kind of crucial civic education.
Let's look at Part 4, Heavy Fines for Businesses.
So beyond just paying compensation directly to the victim, a company breaking these rules is going to face some severe regulatory wrath from the Nigeria Data Protection Commission. Under Section 48 of the NDPA, major data controllers can get hit with staggering regulatory fines going all the way up to 10 million naira.
And trust me, it gets even more serious than that. If the company is massive, the NDPC has the power to instead fine them 2% of their entire annual gross revenue, whichever amount is higher. Just think about that for a second. One unauthorized promotional photo could literally bankrupt a business if they aren't paying attention to the law.
Finally, Part 5, Key Lessons for Everyone.
For the event organizers, business owners, and content creators out there, the lesson here is loud, plain, and very simple. Taking promotional shots at a gathering does not give you a free pass to use people's faces in your marketing campaigns. If you actually want to use a guest's face to sell tickets, you have got to create a clear, separate, plain language consent form. Stop relying on that vague, tiny print on the back of event tickets, because guess what? It is no longer legally sufficient.
And this legal precedent proves something pretty wonderful. The everyday citizen actually holds immense, actionable power over their own personal data. You are definitely not powerless against big brands or these huge popular event organizers. So for the rest of us, the attendees, the individuals out having a good time, just remember this. Your face, your photo, and your personal identity belong solely to you. Full stop. Businesses simply cannot exploit them for profit without your explicit permission. If a company posts your photograph online to push their products or hype their upcoming shows without asking you first, Nigerian law literally gives you the power to strike back, demand immediate takedowns, and seek the financial compensation you deserve. It really makes you think, doesn't it? The power has completely shifted back to the individual. So I'm going to leave you with this final thought. The next time you're out having fun at a party, a concert, or even a corporate event, and you see a photographer's camera flashing in your direction, will you stop to protect your 3 million naira face?